Well, hello there. How is everyone? I hope you are all well on this terrific Tuesday. That's it, baby. It's terrific Tuesday. And do you know what else is terrific? You're terrific. Absolutely terrific. And you look absolutely amazing. And we're going to get into some new court docs. There's 3 new docs in the Idaho 4 case. 2 of them ain't really interesting us. The standard sort of nothingness, you know, the to do with this dismissal motion to dismiss and the argument against it, and that's all hush-hush. But there is one doc that is Judge John Judgeson, who is basically going over and changing some of the rules of courthouse conduct. And it raises a huge question when you read it, and it is, what are they so scared of? And this is my opinion, of course, but I look at it like this. As far as I'm aware, in my ignorance, the court system, the entire system that you've got is supposed to be public. It's so people can be tried in the public eye, given a fair trial. And part of that fairness is transparency. And that is so everybody can see how they're going about their business. But that's not what is happening here. And however much people want to try and stick their head in the sand, there is something very, very wrong about how this case is being handled, especially when you compare it to many, many, many other cases over the years that are equally as heinous, but yet there has been much more transparency around them. Because it's not only that there's simply not a modicum of transparency here. It is completely hush, hush, shut up. We are controlling everything. And if this is a sewn up case, if this is a case where they have what many, many of you people out there believe is a slam dunk, they've got to have more, they've got more, they've got it. You'll see. Wait, and you will believe. If that's the case, again, what are they so scared of? So we have a look at these docs and we'll talk about it, because something ain't right. I apologise, the screen is not as it is usually, because I've broke it. Well, I didn't break it. I didn't break it. It broke. The monitor's broken. So I've had to order another monitor. That's coming in today. So the screen sharing is a little bit out of sync. And by out of sync, I mean I'm overlapping it a bit. But it will be rectified later. So what we've got here is the amended order governing courthouse and courtroom conduct. Now, this order governs courthouse and courtroom conduct and media activities in this case. This order shall supersede any prior order governing courthouse and courtroom conduct. So what has been written before is no longer valid. The court is mindful of the need to balance, funny that, the constitutional right of the defendant to a fair hearing and the public's right to information in conjunction with the constitutional and statutory rights of the media to attend proceedings. The court's interest in maintaining order and an environment that permits all participants to focus on their responsibilities without undue distractions, and the court's interest in the safety of the public and court personnel, and the need to follow all Idaho Supreme Court orders as may be changed or amended from time to time. With these factors in mind, pursuant to Idaho Court Administrative Rules, ICR 45 and 49, it is hereby ordered. Courtroom seating and attendance seating for families, victims' families, counsel, defendants' families, and court personnel. Certain seating may be reserved for counsel, authorised court personnel, the defendant's family, and the victims' families. General public and media seat in the public and members of the media may be permitted in the courtroom as space permits on a first-come basis. No person may reserve seats. No standing in the courtroom will be allowed. No, I think that's something we can agree with. Obviously, the victims' families and Bryan's family should be able to, to be there. And if there's then room for others, then so on and so forth. I do believe that there should perhaps be a small allocation of media in the event that there is no space and they turn around and say, well, we can't have any media in here because we don't have any space left. That would be a bit of a grey area. I can't see it happening, though, but there we go. Anyway, seating in front of the bar. No person other than court personnel. We don't need to read that. Entry and exit during court proceedings. I don't think we need to read into that one. There's a couple that are quite important. Security screen. All persons entering the courtroom are subject to security screening. No food, beverage, firearms, or other weapons are permitted in the courthouse, or handbags, backpacks, or purses are prohibited in the courtroom. Any personal property items are subject to inspection. And that's where we then get into the meat and potatoes. Cell phones. Cell phones are permitted inside the courthouse, but must be turned off and stowed out of view during the proceedings and any court recess while inside the courtroom. Cell phones shall not be used for texting, emailing, recording, or transmitting audio, images, or written accounts of the proceedings to platforms such as Facebook, X, formerly Twitter, Instagram, YouTube, blogs, or other similar platforms or websites while inside of the courtroom. Cell phones may only be used outside of the courtroom. Violation of this rule may result in confiscation of the phone by the court, a bailiff, or other court personnel. Other electronic devices, computers, laptops, other similar devices are permitted in the courtroom for note-taking only and may only be used in a manner that does not interfere with the court proceedings. So I hope you've got really silent keys, not like my mechanical keyboard. Cameras and microphones on electronic devices must be disabled while inside the courtroom. Electronic devices shall not be used to mail, chat, record, or transmit audio, images, or written accounts of the proceedings of platforms such as Facebook, X, formerly Twitter, Instagram, YouTube, blogs, or other similar platforms or websites while inside the courtroom. Violation of this rule may result in us taking your shit. Disruptive behavior. Any activity or behavior which is considered disruptive by the court will result in removal from the courtroom. Any spectator who creates a visual or auditory disturbance of the court proceedings may be removed from the courtroom and or the building at any time at the discretion of the court security personnel. Again, mechanical keyboards, be careful, they're noisy. Video recording, still photography, audio recording prohibited. No video recording, still photography, or audio recording is permitted by members of the media or the public as ordered by the court on the November 17th, 2023. That you've just said this supersedes all that, so you don't need to refer back to that. You just need to put it in this one. Order denying second motion to intervene and granting defendant's motion to remove media cameras from the courtroom. A live stream of the proceedings will be provided by the court and will be available in real time on the court's YouTube page found at yada, yada, yada. The media and the public may capture and use the live stream video and audio footage, but are strictly prohibited from altering the footage in any way, including zooming in on the defendant, live broadcasting, transmitting or streaming by the media and the public from inside the courtroom is prohibited. These prohibitions include during recesses and the court proceedings. So it looks like we can at least use the footage, we just can't change it or manipulate it. Portion of the proceedings that will not be live streamed. Pin your airbags. Pin your ears back. Airbags. The court-operated live stream coverage of the proceedings will not include audio or video of closed hearings. Private bench conferences. Sidebars. between the court and counsel, conferences between an attorney and client, or conferences among counsel. The video and audio recording may be stopped or paused at any time by order of the court to protect sensitive witnesses, exhibits, members of a trial jury, or for any other reason that the court deems necessary. The rest is, not important, because that's the bit, isn't it? That's the bit. They can stop, pause, omit from the live stream certain things. Think about this for a minute, because we're talking about transparency, aren't we? We're talking about transparency, and there is, in this Idaho 4 case, there is a huge missing piece in this. There's a huge missing piece, and there's questions that do require answers, such as the 8-hour time delay. That is a massive factor in this. Because what you're trying to do, in one sense, you're trying to trust that the surviving roommates are, in essence, controlling the entire timeline of when this happened, when this shit went down. But then equally, you've then got to trust that their reasonings behind an 8-hour delay in asking for help is not nefarious in nature. We've heard many, many things. I can imagine that Ann Taylor is likely to try and challenge Bethany Funk and Dylan Mortensen, for instance. Now, shouldn't the public, and even for Dylan Mortensen and Bethany Funk's protection, if you want to go down that route, and they are completely above board and have valid reasons, that the public should be privy to that, so that all this shit can be put to bed. This, to me, there's two things here. That is that they are still putting a gag order or potential hiding stuff that is further going to exacerbate issues that the public has towards certain people in this case, and going to further fan the flames more than them ones behind me, when they could simply offer transparency and allow the public to see everything, warts and all. They're scared of something. In my opinion, they are scared of something. They're scared that something is going to be said that undermines everything that we have previously seen. We already know that there must be some issue between Dylan Mortensen and Bethany Funk and their statement. And the fact that in the background we've had notification of potential exculpatory evidence held by Bethany Funk, that should concern people. It should concern people that they are prohibiting people, when it's live, when they're in the courtroom, to be able to record and and have some form of, I suppose, control over things. The flip side of that coin is, ultimately, if anything gets said in there, then the people who are in there can come out and they can report on it. So if something was said, you have to then trust the likes of Brian Enton, for instance, would give the public a true rendition of what he witnessed inside that room. But if the feed's cut and everything's cut, how do we know what's being said? How do we know who is controlling? How do we know anything? We are the public. We are the public, and we are not privy to it. And you've got to put a lot of trust in it. Let me know down below. Are you trusting of this? Do you think that this behavior shows that there's something missing here? There is this to me is not the actions of a system that has a slam dunk case. And again, like we said at the beginning, for all those people who feel that there is a lot more to come and they have many, many things, is this truly the behavior of a team, a prosecution that does indeed have that? And a judge who is also, from what he has seen, he is confident that the public are not going to see or hear things that is going to raise concern. I don't know. Like I say, I'm not a professional. Maybe I just don't get it. But there's elements of this that gives me great concern. This is a huge case, and the eyes of the public are on it in an abundance. And to me, it looks like they're still saying that they're going to be hiding certain elements of this case that I feel are hugely important that the public sees and hears. Let me know, and I'll catch you all in the live later. There might be a video in between, but certainly a live later. 5:45 p.m. Eastern Standard Time. See you there.